Are you here to support the?
Yes.
Okay.
Yes. As I believe you were doing when I entered slightly late, I think you have our letter of May 11th.
Yes, sir.
Which advised you of our board's May 9 resolution with respect to the joint applications. And in terms of the process leading up to that, I believe you summarized that as well. So I'm going to. I don't need to go into that.
Before you go further, I appreciate your letter of May 11th.
Yes.
Nice in detail. Also, if you can address in that letter, I think you mentioned something about a 2 a.m. closing.
Yes.
Near the end of that letter. And if in your remarks you could address that, I would appreciate it.
Sure. That was a point that was raised actually in our general board meeting after the committee had already passed its resolution, and during the debate of the committee's resolution at our, I believe it was our May 9th meeting.
Made after you met with the applicants.
Made after we met with the applicants. There was an additional amendment approved to the resolution that, with respect to certain time cutoffs for service of alcohol, and where we came out was, I believe it was by the beginning of the fourth quarter for NBA events, at least 1 hour prior to the end of any other event, and in any event, a cutoff of no later than 2 a.m. For alcohol service, which was debated considerably. Some earlier times had been proposed, and this is where our resolution wound up by a vote of 20 to 8 with 1 abstention. And as I had indicated in my letter, I took pains to poll those who had voted against the resolution to determine whether they were opposed to the issuance of a license or simply were voting against for some other reason, and all of them indicated that they were not opposed to the issuance of a license, but were actually disagreeing with some of the conditions that the larger board had attached to our resolution. We communicated that by our letter of May 11th, and that speaks for itself in terms of what the conditions were that we attached, and I think you summarized them in your opening remarks, so I don't need to go over those. And I'm pleased to report that from our point of view, except in one significant respect that we've been discussing tonight, and which I'll go over in a moment, the applicants have substantially complied or committed to comply with all the conditions in our resolution. Now, the remaining divergence between the applicant's proposed operating plan and CV6's resolution stemmed primarily from the failure of complete communications, which have just been acknowledged, with respect to the original presentation to our committee. That's the bad news. The good news is that I think that the communication gap has been closed and remedied in recent days with the supplemental submission to the point where I believe the SLA can proceed to act on the application. Had this additional information about service in the so-called VIP areas been disclosed at the committee, I'm sure there would have been questions about it from the committee, questions and comments from the public, and it's hard to predict, to say in the abstract or hindsight, but it's likely that our resolution would have addressed that. We've accepted their apologies for the untimely disclosure and the representation that there was no intent to deceive the community. You've already discussed the fact that several elected officials did call for the SLA to bifurcate this application and remand the portion concerning the VIP areas back to the community boards. Notwithstanding that call, which was widely known both within and outside our board, there were no motions made from within Community Board 6 at our general meeting last week to reopen the process or to amend our resolution. Thus, our resolution stands, and on its face continues to call for cutting off service at times preceding the end of events. And this evening I have no authority as chair to depart from that resolution because of the current state of affairs. Nonetheless, in view of the concerns expressed by a number of our board members as well as elected officials and members of the public, Mr. Dew, the chair of CB2, and I did open a further dialogue with the arena last week and asked some pointed questions. And I'm pleased to report that as a result of that dialogue and the supplemental information provided by the arena at our request, the arena has addressed, at least or begun to address in good faith, most of those concerns. First, they provided detailed information concerning the 3 areas of the facility at which they're proposing to offer post-event liquor service, including both the legal capacity information with respect to those areas and the anticipated actual usage, which is probably going to come in well below those legal capacity limits. They provided significantly detailed information concerning the types of events at which post-event service will and will not occur. And finally, and of particular importance to us and particular concern, they provided significant supplemental information concerning their security operations, which Mr. Sparks summarized a short time ago, relating to the
I've read the document.
Yeah, post-event alcohol service. I mean, that's the main concern, is that, I mean, what goes on within the arena goes on within the arena, but what the impact on the community will be what happens when patrons are leaving the facility, particularly this category of patrons, if they haven't been driven to the arena, will probably be more likely on average to have driven themselves.
I just wanted to say something to you and to Mr. Ferris. As I indicated before, I don't know if you were here to listen to this. Once I finish with this gets moved on and it goes to the State Liquor Authority. A calendar date will be set. The State Liquor Authority is the entity that will issue a license or not issue a license. And at times, at that calendar date, the chairman will ask for input, and you may have an opportunity, again, the chairman might ask you, so be prepared that, you know, if you want to come and present it again, but your testimony has been noted, it will be passed on to the authorities, and we do thank you for coming today.
Okay.
Do you have anything further to say?
Yeah, I would just simply say, just in closing, a few remarks, more for the benefit of the community.
Okay, I would appreciate that.
Yes, it's, you know, at the risk of sounding a bit Pollyannish, if there's a silver lining to this regrettable and really avoidable episode concerning the late disclosures, is that it ultimately provided a vehicle for increased transparency and a dialogue between the community board and the arena. And as time moves on, we're going to need a solid and good faith foundation for such dialogue on an ongoing basis if we're going to work through the quality of life issues that are inevitably going to arise as it commences operation. And the establishment of that ongoing relationship and dialogue is, at least in my view, one of the primary purposes of community board involvement in the liquor licensing process. And I think we're on the right path now in that regard. It's really in all of our interests that this arena operates successfully, both from an economic standpoint as well as from a safety, security, and quality of life standpoint. And we're prepared to work with the arena management toward achieving all those goals. So in sum, notwithstanding what was a very significant hiccup in the community review process arising from the late disclosure, we believe that your agency is now armed with sufficient information, both from the original community board resolutions and from the applicant's supplemental submissions, to proceed on the applications and craft appropriate conditions for the arena's liquor licenses, assuming they are granted.
Thank you, sir.